All right. Well, thank you everyone for joining me once again. Welcome very much to this session. My name is Lior Samfiru. I am the employment lawyer. Not only that, I'm one of the founding partners of Samfiru Tumarkin LLP. We practice employment law and we help individuals across Canada, specifically in Ontario, in BC, and in Alberta, resolve workplace issues. Well, what does that mean for here? Why am I here? Why are you watching? Well, I'm here now live to answer your questions. I'm here to talk to you about employment law, whatever is troubling you, whatever issue you're having in the workplace, whatever question you have now or you've always wondered about, this is the time to ask it. Ask the question, I'll read it, I'll give you that answer, and you walk away with that knowledge. I'll also tell you what you can do, what you can't do, if your employer is allowed to do something, if they're not allowed to do something. So by asking a question right now, you'll get a lot of answers, you'll get some help. Maybe you've lost your job. Maybe you're off work because of your vaccine status. Maybe you're on a temporary layoff. Maybe your boss is not treating you properly, not paying you properly. Maybe you're bullied or harassed. I can go on. Whatever the issue or the question that you have, what an opportunity you have right now to ask the question. Okay. In most of those situations, there are good answers. The law is quite good. In Canada, we have really, really good employment laws, some of the best in the world. So I'm here to tell you what those are. Let me give you some additional contact information. If you want to connect with me and my team off social media, you want to have a private chat, easy to do. All you have to do is you go to employmentlawyer.ca. You see that right over here, employmentlawyer.ca. Not only can you read a lot about your legal rights there, you can read a lot of interesting things about employment law. You also get the contact information there, phone numbers, email addresses, it's all there. So if you want to connect with me, that's the way to do that. You can send me an email. It's all at employmentlawyer.ca. But right now, on this session, I am live and I'm here with the intention of answering your questions. We always get a lot of questions at the end of the session, so don't wait till the end. You know, you don't want me to say, okay, unfortunately, my time is up today and I can't continue. You have plenty of time right now to ask the question. I get a lot of questions by email every day. So now is the time to ask those questions and get your answers. I'm going to start answering some questions right now, but please don't wait. Ask your questions. By asking the questions, not only can I help you, you'll be helping others. They may have the same issues and questions that you have. So do it for them as well. Okay, Rocket, first question of the day. Can you explain workplace reprisal? And is bringing up a safety concern and getting fired for bringing it up the same. So a reprisal is a situation where you get penalized for pursuing your rights or asking questions about your legal rights. So generally speaking, let's give you an example. Let's say, hey, employer, you didn't pay me overtime, so you owe me overtime. And the response is, okay, we're firing you. That's illegal. That's a reprisal. You can't fire someone legally because they're standing up for their rights. So what happens in that situations, there are going to be penalties imposed on the employer, and potentially the employee could also be, the employer may also be ordered to reinstate and rehire the employee. So it's illegal to engage in a reprisal. Now, you asked specifically about bringing up safety concerns. Yes, if you're essentially demanding that your employer comply with their obligations, for example, under the Workplace Health and Safety Act, and you're fired because of that, yeah, that is a reprisal as well. So not only would you be owed severance, we know that, but there could be other damages as well. Obviously, the devil's in the details, right? We would need to know exactly what it is that you've asked, how you've asked it, how they responded, is it a real issue, etc. But yeah, if you believe that you're let go because of standing up for your rights, that's not legal. You can't be let go in that situation. So by all means, we can always chat about that. And Rocket, or anyone else, if you want to reach out to me, easy. All you do is go to employmentlawyer.ca. Again, employmentlawyer.ca. You see how easy it is to ask the question? Rocket just did. I just answered it. You could do the same thing. I am live on this session. And again, my name is Lior Samfiru. I am the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We're the biggest employee side firm in Canada. All right, next question I'm answering right now from Kara on Facebook. I've worked for the same schedule and amount of hours for 3 years. we have a new manager that wants to change my schedule and has given me something to sign. Do I have to accept this? Absolutely not. Your employer does not have a right to make changes like that. And if you don't sign, first of all, why would you sign? Unless you're happy with the hours, you don't sign. Here's what happens if you don't sign. One of a few things will happen. Number one thing they may do is they may back off and say, okay, fine, we'll just leave you as B. Fine. That's the best case scenario. The second thing they may do is to say, well, okay, you don't sign, but we don't care. We're going to implement those changes anyway. We're going to change your hours. At that point, that change could be a constructive dismissal. An employer doesn't have a right to make significant changes. So if you've been constructively dismissed, you could treat that as a termination. But what you should absolutely not do is sign it unless you're happy with it. So either they'll back off or they'll do it anyway, in which case constructive dismissal. But you signing this, you can't change your mind. You can't then say constructive dismissal. So anytime your boss says, I'm going to do something I'm not allowed to do, but I want you to sign to accept that, the answer should always be, well, no, I'm not signing that. Why would I? And by the way, if you're asked to sign something and you don't know if you should sign it, easy. Just contact me. Let me see it. Let me read it. And I can tell you exactly whether you should sign it, what it says, and what it does. All right. And to reach out to me, very easy, employmentlawyer.ca. Again, employmentlawyer.ca, the way to do that. So waiting for your next questions. And in between your questions, I wanted to ask, to answer some common questions that I get that usually start with, can my employer do ... So one of those questions I always get asked is, or especially these days, can my employer still keep me off work because of my vaccine status? So for those that were put off work, put on a leave because of their vaccine status, no, you cannot be kept off work. It's full stop. First of all, arguably, they didn't have a right to put you off work to begin with. But by now, if you haven't been called back to work, that's not legal, meaning their refusal to bring you back is, the law would look at it as a termination of your employment. That means you are owed compensation. You are owed severance. That severance can be as much as 2 years' pay. If you've worked there long enough, you absolutely could be owed 24 months' pay. So if you're still off work because of your vaccine status, you have two options. First option is you can continue waiting. You can do that. I don't know why you would, but you can. The second option, you can say, no, enough is enough. I am treating this as a termination of my employment, and now I am requiring you to pay severance. If that's what you decide to do, which I think makes a lot of sense, you need our help. You need us to get involved. Your employer is not just going to say, here's the severance. We're going to have to do that. Not a complicated process. We've been doing this for hundreds of people across Canada. We're resolving these cases every day. So if you're in that situation, you need some help, you know your options, and to connect with me and my team, easy, employmentlawyer.ca. You see that address below me, employmentlawyer.ca. All right, next question from you guys. Again, ask those. You have time, everyone. Next question comes from Deborah on YouTube. My employer is making me test weekly for COVID at my own expense. I was given a religious exemption and work from home, so I have no idea why they're forcing me to test. It makes no sense whatsoever. If you're already working from home, to test you to work from home, that's ridiculous. Here's an example that I've been using. Some employers have no perfume policies, right? Because some people are sensitive to perfumes. So they may say, you can't wear perfume to work because people are not comfortable with that. Well, if you're working from home, can you imagine your employer saying to you, you can't wear perfume at home? That's ridiculous. It's the same thing here. So no, Deborah, they're not allowed to do that. So here's what your options are. Option one, you continue doing what you're doing. Option number two is you simply say to them, guy, I'm working from home. I don't think it's reasonable to continue doing this. So I'm not doing this anymore. I'm going to continue working without testing. If they do anything to you at that point, you call me. All right. And I will discuss it. But it's not reasonable for them to say for you to continue working from home, you have to do regular COVID tests. Makes no sense whatsoever. Deborah, any problems, any issues, you know what to do. You reach out to me through employmentlawyer.ca. And I see a follow-up. Do they have grounds to fire me if I refuse? Remember, Deborah, an employer can let an employee go at any time. Okay. So can they let you go? Yes, you can't physically stop them from letting you go. But that's not a quote unquote firing. It's not a termination for cause. They would have to pay you severance. Okay. But generally speaking, an employer can let you go with severance for any reason. If they try to avoid paying you severance, my God, that's a wrongful dismissal. And depending how long you've worked there, Deborah, I don't know your details, but depending how long, you could be owed as much as 2 years pay. For Deborah, for anyone else, again, to reach out to me, very easy to do, employmentlawyer.ca. Now, those just joining me, by the way, welcome. My name is Lior Samfiru. Welcome to this segment here. Welcome to the session where we tell you about employment law and workplace rights, where we answer and I answer those questions. So if you just tuned in and you have a question about your workplace rights, just type it in that little box on the screen. Press the enter key. I'll see it. I'll answer it. That's how easy it is. As I was saying, in between your questions, I'm answering some. Sorry, Deborah, you say you've been there for 6 years. Again, depending on your age and the type of job, you could easily be looking at 8 months pay, maybe even a bit more. So in between your questions, I said I'm going to answer some other common questions that I'm getting. Another common question is, can my employer put me on a performance improvement plan? So some of you have already seen that or heard about it. A performance improvement plan is where your employer is saying, yeah, you're not doing a good enough job, so we're putting you on this performance improvement plan to try to improve your performance. And if it doesn't improve, we're going to let you go. So for you to be put on a performance improvement plan, it has to be done in good faith and it has to be legitimate. So if the employer is making up stuff that you didn't do, or they're trying to trick you, or they're trying to come up with reasons to let you go, then it's not a legitimate performance improvement plan. But if your performance was in fact lacking, then yeah, it is legitimate. The important thing about performance improvement plan is if you disagree with with the reasons you're on, if you disagree with why they put you on it and what they say you've done, you have to say so. Okay? So if they put you on a performance improvement plan, you think it's complete nonsense, but you don't say anything, you just continue working. You've accepted it, you've agreed to it. It's as if you've said, yeah, that's fine. If you don't agree with it, say so. Send an email saying, here's why I don't agree with it. Here's why I don't think you have all the facts. You don't have to be rude. You absolutely can and should be polite about it. But once you do that, but by doing that, you're going to make it that much harder for the company to rely on that to let you go. So very important. You can be put on a performance improvement plan if it's legitimate, and if it's not legitimate, you have to say so in writing. All right, I'm going to continue answering questions. You have time, guys. Ask those questions right now. I know you have them because I deal with them every day, so ask them. Next question from our regular viewer, JC2004. I've heard that during the pandemic, one of my employers has lost the contract for the type of work I do for them. They have not sent me any notification of this or any possible severance offer. I know of a company that likely got the contract. That's how I found out. Should I pursue severance? And how could that impact any future employment at an office in a different province? So I'm assuming you're not at work. If you're not at work, you can get severance regardless of this contract. Okay, so I think you've watched my segment many times, JC2004, so you should know this already. You should know that if you're not working, you're owed severance, regardless of whether they lost the contract or they just decided to put you off work. You're owed severance, absolutely, and you should absolutely get it. There's no point. I mean, if you're not going to ask for it and deal with it, they'll just keep you off. For them, it's less of a headache. Why would they volunteer to pay you severance if you're content not to get it? So yeah, of course you need to get severance. Give us a call and let's get going on that. It's not going to impact your work anywhere else. It has nothing to do with any other employer or any other location. So I don't see any reason in this world where you're not going to get your severance, and you should do that now. And it could be very, very, very quick to get. By the time this session is on next week, you could already have your severance. So by all means, contact me, JC2004, and let's chat and let's get going. My name, by the way, everyone, is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. Operate across Ontario, across BC, and across Alberta. If you have a question about employment law, this is the time, this is the session. Next question from YouTube comes to us from Rick. My private employer has kept their vaccine mandates, even though the government has dropped most, including federal employees. Are they in a strong position still to keep me out of the office? So as I was saying before, they weren't in a strong position to keep you out even before the government changed their minds. Right now, no. If you're not working, you have two options. You can continue waiting, and you could be waiting for God knows when. or you can treat that as a termination of employment. So if your employer won't bring you back, call them, ask them what the plan is. If they say, we don't know, or we're not ready to bring you back, you can choose to treat that as a termination of employment. You can't physically make them bring you back, right? There's no way to go in there and threaten them to bring you back. Absolutely not. But what the fact that they're putting you off when they're not allowed to do that means that you can treat that as a termination and get your severance. So that's the options. Get your severance and move on, or you wait. No, they're not allowed to keep you off. Arguably, they weren't allowed to put you on at all. Even back when COVID was a much more serious issue, they didn't have a right to put you off because of your vaccine status. Certainly now they don't. So if you need help, if you've had enough, if you want to get the compensation that you're legally owed, give me a call at the office or email me. To do that, just go to employmentlawyer.ca, and all the contact information is there. Again, employmentlawyer.ca. Waiting for your next questions, and in between that, as I said, I was answering some questions about things that your employer can and cannot do. So the next question, common question that I get is, can my employer make me come back to work contrary to my doctor's opinion? So you have a doctor's note saying you can't work or you need to be off work for a while, and your employer says, yeah, I don't care about that. That's not good enough for me. You have to come back to work. Can they do that? Absolutely not. Cannot do that. Your doctor is the only one whose opinion matters about your ability to work. Your doctor is the judge and the jury when it comes to that. Your doctor is the only one that can make that decision. So if you have a doctor's note saying you cannot work, or you need to be off work for a day, a week, a month, a year, your employer has no say in that. Your employer can't challenge that, can't say they don't believe it, can't ask you to see another doctor. They can't demand an independent exam. None of that is possible. They simply have to comply with what your doctor says. If they give you any hard time, if they don't refuse to follow what your doctor says, not only can that be a wrongful dismissal, it could also be a human rights violation. So it's wrong, it's illegal, it's not something that they can do. So bottom line, if you can't work, if you need time off work, whether it's for a period of time, whether it's for an indefinite period of time, get a doctor's note. Talk to your doctor, get that doctor's note. That's it. That's all you need to do. Any hard time that you get, you know what to do. Connect with me through my office, employmentlawyer.ca, and employmentlawyer.ca. All right, next question comes from Steve on Facebook. Steve asks, have a doctor's note to take a stress leave for a few weeks. My employer has refused. That's exactly what we're talking about. Has refused it as we're busy in the summer and understaffed. Can they do this? Absolutely not. Your employer doesn't get to decide when you're sick. Well, sorry, it's not convenient for you to be sick now. Can you be sick a bit later? No, it doesn't work that way. If you can't work for medical reasons, whether it's a mental health issue, whether it's a physical issue, does not matter. If you have a doctor's note, you can be off and your employer can do nothing about this. So Steve, all you have to do is tell your employer, sorry, I'm not well, I'm going to be off work, and I'll let you know when I'm ready to come back to work. That's it. They can't do anything else. They can't object. There's nothing that they can do. Why? Because legally you can be off work if you're not able to work and if your doctor supports you. What a silly thing. Well, let's look at our calendars. September is not a good month for you to be sick. How is November sounding like to you? Silly, ridiculous. Can't do that. By the way, guys, we still have some time, easily 10 minutes here. So ask your questions. Don't wait till the last minute. I always get like 3 or 4 questions right at the very last few seconds, and I don't get to them. Don't let that happen to you. You have time to get your questions answered. All right. JC 2004 has a follow-up. What I mean is that they have offices in other provinces. I almost moved to one of those provinces years ago. So if I go for severance in BC with them, would that affect employment through the same company in a different office? Well, I can't answer that. It's up to them whether they want to hire you or not. I can't tell you if they will or they won't. A company can decide who they want to hire and who they don't want to hire. If they decide not to hire you, then they don't hire you, right? So not really something that I can say. That will be up to the company completely. Next question from Tracy. I've read the consultation, which is free, but to talk to a lawyer costs $200. Are there any other fees payable? So first of all, most of our consultations are free, okay? probably of all the consultations we do, probably about 80% of them are free. There are some cases that we cannot do a free consultation because it requires a different level of time and analysis. In those cases, there may be a fee. Now, in terms of other fees, no, that's the only fee for a consultation. The vast majority of cases that we end up taking on after the consultation, the vast majority are on a contingency basis. So there's no fee unless we do everything we said we're going to do. So most of our consultations are in fact free. Certainly the ones that are dealing with termination. If you lost your job, in 97% of the time, it's going to be a free consultation. But we try to do as many free consultations as possible. To give you an idea, across all my lawyers in my office in a given week, we probably have about 150 to 200 consultations every single week. And the vast majority of those are completely free. In some cases, we cannot do that. And when you call us to schedule, they'll let you know if it's free, likely, or if there's going to be a charge. So thank you for that question, Tracy. You have some more time, guys, so ask your questions right now. You want to know more about employment law, workplace rights, now's the time to do it. And let me tell you before we continue answering questions about another tool that you have to know about. You absolutely have to know about. If you lost your job, you need to calculate your severance. Or if you're worried about losing your job, you want to know what you would be owed. How much severance do they owe me? You're deciding, should I pursue severance or should I not? Well, the key question is, if I pursue severance, how much do I get? Here's how you do it. Here's how you find out. You go to pocketemploymentlawyer.ca. You see that on the screen below me, pocketemploymentlawyer.ca. When you go there, first thing you'll see is our severance calculator. Ta-da! Just like the name suggests, it calculates your severance. It tells you how many months of severance you are owed. You answer a few questions, your age, your position, the length of your employment. You press the button and it's going to tell you 6 months, 8 months, 24 months, or anything else. It's easy, very easy. It's free completely. It's completely anonymous. There's no charge. There's no credit cards. You don't have to put in your name, the company's name. No one's going to know you were there. It's just for you to use. pocketemploymentlawyer.ca, the very first place you go to if you're worried about losing your job or you've lost it. And if you're talking to your friends, your neighbors, and they're in a situation where they're losing their job, tell them. Before you do anything, friend, grab your smartphone or your tablet and use the severance calculator at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. All right, easy to do. Check it out yourself. Okay. So NM asks, are free consultations in person? Right, these days, most of our consultations are by phone or Zoom. If there's an interest to do a consultation in person, we can do that as well. So most of our clients prefer to do it over the phone or over Zoom, and that works just as well. But if you need to have a consultation in person, easy to do. You can just schedule it that way. So it's completely up to you. Next question comes from Salem. How often does harassment or bullying lead to a successful constructive dismissal? So it's all about what you can prove. So it's very, very easy to pursue a constructive dismissal because of harassment if you can show that the harassment happened. If it's just your word against someone else's, it's more difficult, right? But if you can prove it because you have emails, you have contemporaneous notes, you have a recording, you have a witness, there's something that you can prove it, very, very easy to pursue constructive dismissal. In fact, some of the easiest constructive dismissal to prove is harassment ones if you have the proof. Keep in mind, the person that's harassing you is not going to just admit it, right? They're not going to say, yes, of course I did the harassment. They're going to deny it. They're going to say, I did nothing wrong. So we need some proof. If you have proof, we can pursue it easily. If you're not sure how to get proof, or if your proof is good enough, just as easy, contact me, contact my team. We'll look at it. We'll tell you exactly where you stand. And to do that, of course, you know how to do it. Employmentlawyer.ca. Again, it's employmentlawyer.ca. All right. AJA on YouTube has the next question. Can an employer withhold a record of employment? It has been 2 weeks and they have not electronically submitted it. EI application is pending because of missing record of employment. No, they can't. So you can tell the EI office, or you can get us to send them a letter threatening them, so to speak, and they'll do it. So easy to resolve, but you need to do something about it. If you just wait, maybe they'll forget or they'll put it at the bottom of their list. So we can send them a quick letter, or you can talk to the EI people. That's going to take longer before the EI people deal with it because they're overloaded. So you may even write to your employer and say, hey, if you don't get the record of employment filed by Monday, I'm going to speak to a lawyer. So you can try that as well. All right, Rocket has the next question. And by the way, we have the last 5 minutes or so, so still plenty of time to ask your question. I know you're watching, you're wondering, should I ask, should I not ask? Of course you should ask. Ask the question. I'll answer it. Very easy to do. And doing just that is Rocket, who says, I'm currently looking for work in the open market. And if I tell my employer that is that cause for dismissal. Also, is it a conflict of interest if you're working for two employers in the same industry? So I'm not sure I understand your question. What is cause for dismissal? Is it a conflict if you're working for two employers in the same industry? Yes. So if you're working for two companies at the same time, they're essentially competitors, it may be a conflict if they don't know about it. So you should always find out from them, make sure that they're okay with it. Listen, if you're working for McDonald's during the week and on the evenings you're working for Harvey's, that's not going to be an issue. But if you have a job where you're dealing with the same customers and you're working for two companies, that could be absolutely a problem, and you should not do that without making sure that both companies are okay with that. That could be cause for dismissal. All right, so be careful with that. Next question comes from Great Thesaurus. Oh God, I love that name. On YouTube. What are damages in a human rights claim for discrimination if you're still employed for the same company? Well, okay, that's difficult to answer. It's like asking, what are salaries in Ontario? Well, it depends on the job. So if for discrimination, depends on the discrimination, depends who discriminated you and the impact on you. It could be from as little as $1,000 to as much as $100,000 or more than that, right? So I would need to know exactly what happened, how that impacted you, how long it happened, who was involved. So there's a lot that goes into that. Generally, the awards are not huge, but they can be substantial depending on the situation. Okay, so I understand Rocket's question. It says, is telling my employer I'm looking for work in the open market cause for dismissal? No, absolutely not. It's not cause for dismissal. They may decide to dismiss you, but it's not going to be for cause. They'll have to pay you severance. So telling your employer, just so you know, employer, I am looking at other opportunities, that's not cause for dismissal. Absolutely not. Some employers may say, well, then I don't want you here. I want you gone. And they can do that, but they would have to pay your severance. Absolutely. So it's not cause, but it could lead to a dismissal without cause, i.e. with severance. Roy says, good morning. Good morning, Roy. If you have a question, you have about a minute to ask it because we have very limited time. Great Story says, not accommodating for family status. Again, I would need to know much more than that. So by all means, contact me so I can find out exactly what happened. Awards can be from anywhere from $1,000 to six figures, but the devil's in the details, all right? Let me mention again, we already know, by the way, that if you lost your job, you can calculate your severance at pocketemploymentlawyer.ca. But there's other things that you can do there. If you want to find out if you've been constructively dismissed, we have a tool at pocketemploymentlawyer.ca that allows you to find out if you've been constructively dismissed. If you want to find out if your matter is considered a human rights violation, we have a tool for that. If you want to find out if you're an employee or an independent contractor, by the way, a lot of people are misclassified, we have a tool for that. So Pocket Employment Lawyer, like the name suggests, it's like having your own lawyer in your pocket, in your phone, with you at all times. It's free and anonymous. So I took the most common issues that I deal with and I created this program that by answering some questions, you can get answers anonymously, completely free. Check it out. It is the unique tool of its kind in Canada, probably in the world. I haven't seen one. So check out pocketemploymentlawyer.ca. Guys, this is the time that we have for this session. As always, you guys ask the best questions. Really, you do. So I'm glad that I was able to answer them. But right now, when I'm going to turn off this webcam here, I'm not going anywhere, right? I may take my jacket off but I'm going to get back to work. So if you have questions for me, you can easily ask them still. If you have issues that you need some help with, easily to do that. You just go to employmentlawyer.ca. Phone number is there. Email address is there. Not just for me, for my whole team across Canada. Okay, so don't wait until next week when I'm back here on this camera. Contact me today if you have an issue. Okay, employmentlawyer.ca. My name is Lior Samfiru. I'm the employment lawyer. Always a pleasure to be here with you. Thank you for your time. Wish you all the best, and we'll talk soon. Take care.